recognized for 5 minutes.
Thank you, Mr. Chairman. Take a deep breath. It's been a long day. I'm going in a slightly different direction. 1702D3 is the subordination section, and I will be getting back to that. But first, I draw your attention to 1702G4A. It's a slightly different, it's the same question with a slightly different legal basis for it. And that would be, the language of that is, if the borrower defaults on an obligation, the Secretary shall notify the Attorney General of the default. I point out to you December 13, 2010 letter to Solyndra from Mr. Silver, Jonathan Silver, who is the head of the program, and that is not in your book. Mr. Chairman, may that document be admitted to the record by unanimous consent?
So ordered.
And if we could get a copy too.
What is
Reserving the right to object.
Here's a couple copies. It's a letter from Mr. Silver, who testified previously, the Executive Director Loan Program, to Solyndra Fab 2 and to Solyndra Inc. In that letter, he notices them that they are in default. This is December 13, 2010.
Gentlemen, suspend. Without order, without objection, the document is part of the record. Thank you.
Thank you. In that document, he notices the Solyndra folks that they are in default, and then goes through the reasonings why that's in default and says that the department is not going to waive any. If it doesn't take action immediately, it's not waiving any of its rights under the contract. Further, I would point you to what is document 67, which is the memorandum from Susan Richardson authorizing the subordination, and in that she indicates in paragraph 3, first sentence, a default relating to a financial requirement has occurred under the loan agreement with that when that default occurred on December 1st, 2010, $95 million of the guaranteed loan commitment remains to be advanced. And further, in an email from tab 59 in February, Silver further acknowledges that there was a default in December by Solyndra. That being said, Mr. Secretary, did your office, in compliance with the code 1702 G4A, the section that requires if a borrower defaults, the Secretary shall notify the Attorney General of the default, did you do that?
First, I have to look back at this code of the Justice Department. Now, this particular letter is about...
I'm just asking you if you notified, when there was a default in December, did you notify the Attorney General as required by the code? I'm not asking you for your interpretation of the letters. I've laid those out. Everybody can look at those later. I only have a certain amount of time. I want to know if you notified the Attorney General in accordance with the law.
That I would get back to you on that. But this was a deposit in an equity.
So you don't recall, I understand, but you don't.
Right.
Line is your people said it was a default and it looks like a default. And on a default, you're supposed to notify the Attorney General. I'm just asking you, did you do it? Do you have any recollection of doing it?
I don't have. I'll get back to you on that.
Thank you. I appreciate that. Let me ask you this. Do you know what the value of the patents and other IP, intellectual properties of Solyndra are? Do you know what those values are?
No.
Do you believe that they have value?
They should have some value, yes.
And do you believe it will be greater than or less than $75 million?
The IP, I couldn't have any way of assigning that.
Okay. And I would draw your attention to tab 68 in your book. This is, we're now talking about, it appears from that particular tab. Do you have that in front of you?
68, yes, I do.
Okay. It appears that there's something going on. It's during the time period that they were beginning to discuss the subordination, and a lot of it is redacted. Do you have any idea who that was from and who it was to? It looks like it might have been from Susan Richardson.
No, I don't.
And do you know why all of that information was redacted?
No, I don't.
Can you find out for me as to what the purpose? I mean, I understand there may be some reason, but can you find out why all that information was redacted?
We can get that back to you.
And were you aware that there were numerous discussions about Solyndra's default and the problems they were having, and subordination came up fairly early in December of 2010? Were you aware of that?
I am now that they were thinking of subordination, but again, one can't move forward until one understands the law.
But do you understand that the Solyndra was looking at bankruptcy at that point, and without some understanding that there would be $75 million, they would have had to file bankruptcy pretty quickly?
That is my understanding. About that time scale, they had this cash flow issue, and they needed funds to continue, and that's why one restructures.
And I understand that, but don't the records reflect that there was already an understanding within the Department of Energy with Francis Chu that there was going to be a subordination even before the lawyers had had an opportunity to determine whether or not they could?
We do not do anything until, is it okay to look at things in parallel? Yes, but before our lawyers determined whether it was legal or not, we could not move forward.
But do you understand that based on the documents that have been provided, it's pretty clear from the record that Solyndra would have had to have filed bankruptcy, that the investors were not willing to put the $75 million in unless DOE subordinated, and therefore, when writing the legal memorandum, everybody in your department knew that unless they could figure out a way to subordinate, Solyndra was going down? Sir, isn't that true?
No, that is not correct. Our counsel's office, General Counsel's office, and Susan Richardson, the responsibility as lawyers to protect the Department of Energy, to make sure we act under the law, that always comes first.
You know, it's interesting. I just question why you didn't, and I go back to some of the other questions, why you didn't get opinions when you had OMB and Treasury saying that they didn't think it was legal, why you didn't go to Justice. Were you afraid of getting an answer that you didn't like?
First, gentleman's time has expired.
I yield back.
I think you should let him answer.
Oh, no, I want to let you answer. Go ahead.
Okay, certainly. We are required to go to Justice because if there was an of the loan that meant we were not going to get paid back as much, things of that nature, we went to Justice. We did, as you know, go to outside counsel and sought other opinions. And as noted earlier, there was a previous General Counsel of the Department of Energy, upon looking at the decision, also concurred with that decision.
Gentlemen, time has expired. Gentleman from Kansas, recognized for 5 minutes.
Mr. Chairman, if I might, because I haven't seen it, I've only seen the draft that flags that you can't do the subordination. If we could get that outside counsel's opinion, I would greatly appreciate it.
Mr. Secretary, can we get that outside opinion?
Yes.
Is that possible to get it today? Do you have access to that?
I don't know about today. But
we have the...
but we have an opinion of the previous General Counsel of the Department of Energy.
But I think the gentleman's asking for
I'm asking for what you had at the time the decision was made, not Monday morning quarterback and cover-up.
We can certainly make those records available.
Mr. Chairman,
we need the final is what the gentleman is asking for.
That is correct.
Okay, correct. The gentleman from Kansas, recognized for 5 minutes.